All right, ebusunya mamu nyina makwa abasonko so eba Ghana Politics Avenue, in short AG Politics Avenue. Ohana open all the trending political stories in Ghana. Unsabi tumi akada ebusunya ene nsema de beda mu ye da musu nsembe nya bɔ ne beda ya de bedu mu yetifo fa OSP ene attorney general nsem ho nsem ko pie wo high court na high court kan OSP ko appeal yenze ho high court William ba obi e che na adu obi e ma commentary dance na baba story ni mu ene ndi kan ba channel yi so ni ye lu bo kon so be subscribe to channel to baba subscribe button so no ho adoma na won che notification bell no do so abo se be ya video fu bi e baba du mu bi am on sabi tumi aka bi no hu de ko so Ghana ya man no sem ni e kebe mi kebi amemu a ye bu no Ghana ha ho afi memorial story na ye OSP ene edina no yi disem aba abonten a on so kire na adwen efa high court decision de ba any supreme court interpretation more trans beba na minority dom kuma mo ma she bedwam afie MPP for so de omun anu betum bi na manfo choma adwen se mun come on into omun college se amna we afa ba afa on be ye den na se ehun sem bibre na odi mo yenko ti OSP anu bi sem ni minority for no so ni ti neutral lawyer so nchechi mo de bedum na se ensem no akoyi bibuja obi ehun left and right ehun de ekọ ehun de eba Ghana Police Avenue open all the trending podcast stories in Ghana. Na saboka mi nkuti nchichi mu awolo and my waba no need TV3 for edge chunku yekuti ba they do be and esan bechi bi. Ghana Police Avenue.
From them that they make the points, one of which has been backed by the minority in this press address, that the High Court does not have the jurisdiction to, in effect, strike down part of an act of parliament as unconstitutional because from where they generate the authority from to have gone about the duties as which they did was the Special Prosecutors Act 959, Act 959. And so they argue that it is only the Supreme Court which can strike down parts of an act of parliament as unconstitutional. And so the office is taking steps to quickly overturn the decision of the general jurisdiction of the High Court. That is what we've known of the OSP's response up until now with respect to this matter. With respect to the specifics as to the Act 959, they make the argument that the office was duly created, and like I mentioned, Act 959, and that the matter concerning the prosecutorial powers of the OSP has yet to be determined, which you had the minority make mention of, and that all criminal prosecutions commenced by the office remain valid, essentially challenging the position of that High Court, but they are yet to do that officially before any court, and that the Office of the Special Prosecutor will continue to proceed with prosecutions based on its mandate under the Act. So that has been the position of the OSP in relation to that High Court decision, right? That High Court decision from last week, which has got everybody talking. But let's also look at the provisions of Article 88, which has come under scrutiny. And for lots of persons, it's been very clear from the onset as to what all of this means, right? They've been very clear as to where the powers lie with respect to who prosecutes on behalf of the state. And that's what I want to show to you right now. And the provisions of the Constitution is pretty much clear. And I'm sure for those of us who've been following, you would have heard Article 88 for a very long time in the course of all of the conversations since last week. And so 88.1 makes provision for the Office of the Attorney General, and that it shall discharge such other duties of legal nature. This is why it gets interesting. The 88.3 is which has become the entire debate, that the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses, from which arguments are being made that, look, the powers of the OSP ought to be gleaned from this 88.3, which will require a constitutional amendment to allow for that to happen. Then the 88.4 provides a bit more in terms of when the Office of the Attorney General will not be present to prosecute, what it can do, that it will be at the suit of the Attorney General or any other person authorized by him in accordance of law. Let me take you over the phones right now and speak to constitutional lawyer Christian Mamhesi, who's been keenly following this conversation and get a bit more from him this afternoon. Counsel, I appreciate you joining us this afternoon. Your thoughts on the position of the minority who say that, look, there has to be a position taken by the president with respect to the ongoing matters. Where do you stand on this? Because for some, the president has already made his position clear that he backs the OSP and expects that it will be given the free room to do its job.
Yeah, good afternoon to you, my brother, and to your viewers alike. I mean, indeed, it is a good call, and a poster by the president would show his commitment to the prosecution of corruption and corruption-related matters. But that's it, dealing in that's in the political context. Now, this is more of a legal issue. Now, save that it is a legal issue, the question further deals with first with the construction of the provisions of the OSP Act, but particularly looking at the object of the OSP Act, which verses with two terms of legal words, which is the prosecutorial and then the investigative powers. And then when you come to section 4.2, it deals with the fact that it deals with the subjugation of authority to the Attorney General. Now, if you run it by Article 88, you look at 88.2 and 88.3, which also vests powers in the Attorney General to be the lead prosecutorial authority as far as the state is concerned, and matters that are to be prosecuted on behalf of the state should be mounted on matters of the state that is in that regard, it's in the name of the Republic. And by that, authorization Article 88.3 approval should be sought from the Attorney General. Now, the question is, by the exercise of jurisdiction of the High Court, would we say the High Court applied the law or it engaged in interpretation and enforcement? Now, if the High Court engaged in interpretation and enforcement, to that extent, we say that the High Court has exceeded its powers. And by that, what the minority is saying, it should go by stay of execution. It will not be stay of execution. So we go for stay of execution when the matter is over. But it seems that the matter is ongoing and given it, so then they stay proceedings and go to the Supreme Court for either appealing it or when you come under the rules of certiorari, where the court exceeds its powers, you go under certiorari to quash the decision of the High Court. So it is a question in law of interpretation whether indeed the High Court has exceeded its powers. And if you look at the case of ex parte Rawlings, which indicated that, I mean, the old law at the time was the My Kankan, but My Kankan was not necessarily set aside. It indicated that the High Court could exercise jurisdiction in terms of application of the law, especially so to avoid the Supreme Court being undated with a lot of interpretation matters. But a clearer statement or a clear principle was evolved in the case of ex parte Rawlings, where Dr. Tubugua had the opportunity to further explain the position that in the situation where the jurisdiction of the High Court is raised, or in the course of trial where issues of interpretation comes up, the question that the High Court ought to vest itself with is whether or not the question raised is a matter of ambiguity. And when that issue comes up, such that placing value on the text and content will create variance in terms of interpretation, then the High Court ought to stay proceedings and refer the matter to the Supreme Court. If indeed it is one that the High Court failed to do, then we can say that the High Court has exceeded its jurisdiction, especially when it is that it didn't apply the Constitution, but engage in interpretation. So this is the matter that is of legal controversy that ought to be satisfied.
Right. Counsel, and until we get that final determination from the Supreme Court, we'll continue to be at this point, not knowing in clear terms what course of action the special prosecutor or its office is expected to take, considering they haven't provided any other details but for that initial statement reacting to the development. Where do we go from here? I ask that to mean that the debate is not stopping, and the opinions continue to come in every now and then, with the minority even now asking that the president states his position and all of that. Will this now rest solely on the Supreme Court to make a speedy determination of this matter so all of this can be brought to some end, and then we can know whether or not the OSP should be seeking authorization or they will not need it going forward?
I mean, simply state that this matter borders heavily on constitutional and interpretation law. And politics of the political sphere cannot cure this. So it would be in the essence of the Supreme Court to put this matter to rest. And as it has already been said, one believes, or most constitutional and interpretational law experts believe, that for the OSP to have true position of prosecutorial powers, then Article 88 ought to be amended so that indeed the OSP would have that independent prosecutorial powers without having approval or being subjugated to Attorney General, depending on which government is in power. Right. And so, just as said, in conclusion, my point is that this matter ought to be stayed. The matter refers to the Supreme Court for eminent interpretation so that it puts this matter to rest. Other than that, further steps that the OSP takes would risk being set aside, and it will not be in the interest of the taxpayer for resources to be put in prosecution, which persons who are suspects and their lawyers would have a fine day only to bring such technical legal details out to frustrate the work of corruption prosecution. So it is everything necessary for the Supreme Court to deal with this matter in the earnest of time so that there will be a legal resolution to the whole matter.
Absolutely. Counsel, I appreciate you speaking to us this afternoon. That's Christian Malmhessations, and continues to dominate conversations. That has to do with the tangle between the Office of the Special Prosecutor and the Attorney General's office, because the minority in Parliament is urging the Office of the Special Prosecutor to immediately file a stay of execution to challenge the High Court's directive ordering the Attorney General to take over all ongoing criminal prosecutions being handled by the OSP. The caucus also wants the OSP to file a writ of certiorari at the Supreme Court to quash the High Court ruling, arguing that the act establishing the Special Prosecutor's office still remains valid until the Apex Court decides otherwise. At a press conference today, the NPP MPs tabled a sequence of events which they believe is an attempt by government and its assigns to remove the office.
The fullness of time. The minority sets out the complete chronological sequence for the record of history and the judgments of the Ghanaian public. 3rd December, Martin Kpebu was detained and subsequently released. On 8th December, Majority Leader and Majority Chief Whip came by a private member's motion and bill to repeal the OSP. 10th to 11th December, President Mahama publicly rebukes and says that they must discontinue. 12th December, the very same day, the minority called for the resignation of the leaders of the majority bench. One Noah Adamte files a suit at the Supreme Court. 25th December to 1st January, a coordinated campaign of petitions were mounted against the OSP. On 26th January, Chief Justice Bafo-Boni determines that not a single petition had a prima facie value. 27th January, the Supreme Court dismisses the OSP's application to be joined as a party to the Adamton suit. On 8th April, Attorney General files submission at the Supreme Court siding with the plaintiff, Adamton. 15th April, exactly 1 week later, the High Court grants a quo warranto to Peter Hyde and declares OSP's prosecutorial powers null and void. This is not a sequence of coincidence. It is a campaign, and the minority names it as such.
Well, the caucus has also denounced the conduct of the Attorney General and described the High Court verdict as a judicial rascality.
On the constitutional propriety of the ruling itself, the minority stands firm. Article 1301 of the 1992 Constitution vests exclusive original jurisdiction in the Supreme Court in all matters relating to the enforcement or interpretation of the Constitution. A High Court cannot, through any procedural vehicle, quo warranto or otherwise, effectively nullify the provisions of an Act of Parliament on constitutional grounds. This would amount to judicial rascality if this were to persist. That is not the province of the High Court. It is the exclusive jurisdiction of the Supreme Court, and no other agency can share it with the Supreme Court. The OSP correctly stated in its immediate post-ruling response that the High Court does not have jurisdiction to, in effect, strike down parts of an Act of Parliament as unconstitutional, and that it is only the Supreme Court which can do so. As far as we are concerned, Act 959 remains valid, in force, and unrepealed. The Supreme Court has not spoken. Until it does, Act 959 is the law of the land. The OSP's mandate subsists. No High Court ruling, however convenient or however exalted the judge is, can challenge that.
Well, in a set of demands, they want the president to publicly pronounce his position on the raging debate, hinting at initiating a process to summon the Attorney General before Parliament for a public inquiry.
The High Court ruling must be immediately challenged and stayed, and we call on the OSP to immediately appeal the decision of the High Court and immediately also apply for a stay of execution at the High Court. And we dare also add that he must also proceed to the Supreme Court with a writ of certiorari to quash the decision of the High Court. We call on the Supreme Court to expedite its determination in Adamton versus the Attorney General. The Supreme Court question must be resolved definitely and authoritatively by the courts alone, by the court that alone has jurisdiction to resolve it. We call on the Honorable Chief Justice to treat this as a matter of great public importance, warranting urgent scheduling. The Attorney General must be summoned before Parliament to account for his position. It is constitutionally unacceptable for the state's chief legal officer to actively argue against the statutory institution of the Republic in judicial proceedings without parliamentary accountability. The minority will table appropriate questions and, if necessary, move for a formal parliamentary inquiry. We call on President Mahama to come clean with Ghanaians. He cannot continue to claim publicly that he supports the OSP while his own Attorney General argues for its constitutional destruction at the High Court and the Supreme Court. The president must choose, and he must choose publicly. Does he stand with the OSP, or he stands with the campaign to destroy the OSP?
Well, Well, so all of this is coming together quite nicely. We'll get onto the phone pretty shortly and speak to private legal practitioner Christian Mahama on this latest position as well by the minority. But I want to take you to the screens by my left so we can put a bit more context into all of these conversations. So the minority is asking that a number of things be done. One of such is going to the Supreme Court to, amongst many other things, quash the High Court ruling, which pretty much said they have no legal authority to be prosecuting matters of corruption in any court, and so they should seek authorization from the Attorney General before proceeding. Well, in the wake of that, the Office of the Special Prosecutor had these to say. These bulleted points which we've put together is pretty much the only response which we've got from.
We are told they blend the fish and the meat to mix with a stew so that the food can be balanced diet. But for fish, we don't see with our eyes, but we are told it's been blended into the stew. I'll be speaking with the coordinator. Let's take a listen to it.
Right.
Schools resumed today, and as part of my normal routine, I'm here to actually monitor to see whether the caterers have been able to start with the delivery of the service on the reopening day. We are currently here at Zion Cluster of Schools at Yanyanu, Kaswa, Kakraba. So I think what I've come to see here is that they don't have a cooking area on the premises, that is a kitchen or a shed. The caterer cooks from the house and then brings to serve the children here.
All right, I was in the middle of some break. Now, then, stories said, Bram, just go through fully. I GH Politics Avenue, Ghana Politics Avenue, all the trending podcast stories in Ghana. Ayana and Sabakan, and any day can all buy a few issue and answer a channel issue. And if you do book on the best of the subscribe channel, Nafi, notification bell on Sabo, Sabaya. Video any video of Ruby at Baba Doom will be an also Sabit Macabino, who the Apostle Gan. A man of Semu, any Cabinet, a memoir practice no Ghana. Now, after story at the Bremy, when you want, and if you book was the best of Obel like video, no share my frost when you begin. Obel like it, will like you and no share Ama for frost and your beer. No, said the Belms with me, who the Apostle Ghana. A man of Semu, no much to master with double wombra. I feel so. Comment sessions don't leave them to Chirawadu or Nam Swincher Maduni, Nine Chile. Na Indians I was on no baba or 9 hours more in. Ye who the bay a bit my boy, Amagana, a man of some make a mimic a moon across. And then we know Master Samadi Bridge, I gonna preserve a crown.